Well, let's stay with the story. The two former VBS executives have both entered into deals that have seen them receiving lighter sentences in exchange for presumably implicating more people, especially those that are considered high-profile individuals. But the question is, with the role these two have played in looting this bank, which has since collapsed, what sort of criteria is used when reducing sentences? To help us answer these questions and others that are related to it, we're joined by former NPA head, Advocate Menzi Simelane, and we're also joined by independent attorney Tyrel Singh. To both of you, gentlemen, thank you very much for your time. Let's start with you, Advocate Simelane. When reducing sentences for people who have admitted to the crime, help us understand the criteria that is used by prosecuting authorities.
Well, thank you. Good evening to the viewers and good evening to you, sir. Now, the most important thing that is taken into consideration is state resources. The conduct of investigations, the conduct of running around looking for people, looking for evidence, takes time and costs money. If there's somebody who is available to make that information available, it saves a lot of time and it saves a lot of money. So the police and the prosecution look to that mostly because you are helping the process. And that is why when they identify a suspect and they speak to a suspect, that is what they seek to find out, how much the person knows and how much of the evidence the person can give them so that they don't spend time going around looking for them. So that's the primary criterion.
There's more questions, but I'm going to perhaps insist on this one.
Yeah.
Is there priority given to this person receiving a lighter sentence in exchange for him revealing others, and perhaps the ones that law enforcement would consider much more important to get into custody?
Well, no one is more important than the other. What generally happens is that when the police and the prosecution have looked at what they could get on their own without the assistance of anybody, they make an assessment of how far what they have takes the case forward, where they want it to go. If they're of the view that it doesn't take them as far as they would want it to go, but one of the accused or one of the arrested persons or the arrested individual is able to take them there, then the process of bargaining begins to say, with what you have, which is what we need to take us to where we want to go, if you give it to us, that enables us to achieve what we want to achieve. What arrangement can we make with you to enable you to be willing to assist? Most of the time, you must remember, the prosecution and the police usually already have enough to convict the individual they are talking about. They usually already have enough.
Yeah.
So they don't usually need that individual to convict that individual. They need that individual to get to other people. So what the individual then gets faced with is somebody who says, I'm already done for, I'm already caught, there's nowhere else for me to go. So what I'm facing is possibly the harshest sentence the prosecution will ask for. And usually the prosecution will tell you that we're going to ask for 45 years imprisonment and will argue all the aggravating circumstances that are in front of us. But if you are able to assist us, let's look at how you can also be assisted to rehabilitate yourself and be reintegrated back into society. Because government, you must remember, the government is not in the business of revenge. Government is in the business of assisting society get better and better and better. So even the worst that we find in society need assistance to get better. And when people are usually on their own and caught in that situation, life happens and they do wake up from whatever stance they would have been suffering from, and they face reality.
Yeah.
And then they start making a bargain that they believe is in the best interest of everybody.
Mr. Singh, let's come to you.
Yes.
You are going to give us a perspective, but in the eyes of the ordinary public. You are from an independent law firm, and that's why you're here in your capacity as an independent attorney.
Yes.
When the prosecuting authorities get into these agreements, I don't want to complicate the question just yet. What would society ideally be expecting? Because oftentimes there is disquiet about people who've done wrong, and they go and confess their crimes in exchange for lighter sentences. As we sit here today, Philip Truter is one of those implicated in VBS. Let me read to you what we were told on this channel today. He was sentenced to 10 years in prison. 3 of those were suspended. In total, this is according to Mr. Singh Correctional Services, he spent 3 years and 6 months in prison. He was let out in April of this year. What is society's expectation?
Thank you for the question, and good evening to the viewers. For society at large, it would be restoration of their losses. In these circumstances, I don't think during the period where Mr. Truter was imprisoned, any money has been paid back to the victims of the crime. So society doesn't, surely they want to see people behind bars, but at the same time, they need to be restored for their earnings. Because at the same time, these investments were investments of life savings and hard-earned money. You know, we're talking about funeral stokvels, ladies' stokvels. You know, these are the kind of savings where people put their life savings into it. Their kids were going to go to school with this money.
Yeah.
You know what I mean? So at the same time now, we have to speak about the crime fitting the sentence.
Yeah.
And at the severity of these allegations and these confessions does not match the sentence.
Mr. Simelane, you come back into the picture then, because in the case of Mr. Truter, and I'm glad we're talking about this because now we have a case to which we can refer.
Correct.
The Correctional Services spokesperson tells us on this channel that there was no victim impact assessment as such, because this was a crime that the state sees as having been against an institution. But that institution had monies of the poorest of the poor. How is it that you can assess the person without at least choosing, let's just assume, 3 people who had their life savings in this bank? How can it be? Is this fair to the people who lost monies in this bank?
Well, it's not unfair, but it can be better. The system can be improved. I think traditionally, victim impact assessments are in relation to individuals that would have personally suffered the crime, as mostly in violent crimes, as it were. So in non-violent crimes like this one, I think there's room to be made to make provision for victim impact assessments as well. I think Uzwide is correct that in this case, the institution, being VBS, would have been best to come forward and speak on behalf of its depositors, or former depositors, as it were, and make an argument whether or not parole should be given in this particular instance. So those currently in charge of VBS, or what's left of it, whether it's curators or the Reserve Bank, as the case may be, or even National Treasury even, going forward, have an opportunity to come and make a case in respect of the other people. It's too late in respect of Mr. Truter now, but in respect of future people who are eligible for parole, should there be more convictions, a case can be made that parole should probably not be granted at that particular point in time.
Yeah. Mr. Singh, let's use another individual, because people relate better to cases that we all remember.
Yes.
So Chifuwa Matodzi is the chairperson of this bank. He's now been convicted because he confessed. Arguably, he is probably one of the biggest beneficiaries. 300 million is what accrued to him, fraudulently so. He took those monies, was living a life of luxury, helicopters, very big machines, holidays overseas. Now, he is given a 15-year term in all probability, once he has served, what, a third of that prison term, he's probably going to be out in no time. You spoke about the crime fitting the sentence. What would society's expectations be here?
I think at this point and at this juncture, society, like I said, would need restoration in some form. The fact that there's a leaked affidavit implicating more higher-ranking officials would now mean that it's now the onus has been shifted back onto the state to say, how can we firstly investigate these allegations in the affidavit? Affidavits are usually on oath, and you are not meant to lie on an affidavit. So by that juncture, let us now go and investigate before we make deductions. Let's investigate this and let's restore the public's confidence in our justice system. I think what now we need to see leadership in society from our government to say, how can we hold these people accountable so that this never ever happens again?
Advocate Simelane, the truthfulness of what is said
Yes.
by the person who is confessing to a crime,
Yes.
is there a possibility of reversing or them forfeiting the agreement with the state if it is found that what they have said in the affidavit, Mr. Singh refers to an affidavit, and there is the affidavit that
Yes.
the prosecuting authority has said it was indeed leaked. How important is it that whatever they say in that document,
Yes.
it is truthful?
Well, that's the most important thing. You've got to be truthful to get the deal in the first place. And usually before it's even signed and taken to court, it is proven, it is established by the prosecution and the police that what is put in there actually does exist. So most of the time, as you'd have seen in the Matodzi affidavit, that there's annexures to it. So for every allegation that is made, the affidavit itself is almost 70 pages, as it were, but the full document is 263 pages. The rest of the pages is annexures, which is, if there's an agreement, it will be annexed there. If he makes reference to a bank transaction, it should have been checked with the bank and to be established that the bank indeed has had that transaction run through it. And there would be quite a large chunk of proof. Otherwise, the court would not have convicted him. So in a case like that, when it goes to courts, it's when the prosecution and the police are satisfied that the necessary evidence is there. Because remember, that evidence is required to convict that particular individual, the deponent to that affidavit, which the court wouldn't do without the evidence. So which means it's evidence that's been checked by a judge. The judge, remember also, is not required to accept a plea and sentence agreement that's concluded between the parties. The judge must still assess it independently of what everybody else says. So if a judge is not satisfied that the plea and sentence agreement doesn't add up, the court wouldn't accept it. It would reject it and send the parties back. So if it is accepted, like it has been in this case, and he has been sentenced, you can rest assured that what's in there has been checked and verified and is correct.
So this is interesting then, because this affidavit that's been leaked,
Indeed.
is that affidavit now not part of the court record, given that the individual who signed to whatever is said in there has now been convicted and sentenced based on that very agreement or very document? Is that not part of a public record now, or should we say a court record?
It is a court record. It is public record now. All court documents, once they're filed in court with the registrars or the court clerks, are public documents and anybody can really access them. I think what the NPA is correctly complaining about is it's looking at its own ranks amongst the people that were responsible for handling that file, in that they would have probably agreed how they want that information handled and contained so that it's not too widely disseminated. And what has happened is that if somebody released it outside of that understanding, then that individual who's within a broader team, whether it's, it's the police, the prosecution, well, within the state, even court officials, as the case may be, that individual would have undermined what the team is trying to achieve, which is to contain the damage that would come with making that information widely available.
But it's not necessarily illegal for the document to have been made available because it's part of the...
No, it's not. No, it's not.
record.
Also because it's not restricted, it's not marked. If it was marked confidential, secret, or top secret, it's a different story. But it's a normal document on any A4 paper with a lot of content on it.
So the use of the word leaked by the NPA, neither here nor there, is it?
Yeah, it's neither here nor there. It doesn't take anything further. It's just an indication of how seriously they take the undermining of everybody's effort in the team by whoever made that document available.
Yeah. Mr. Singh, a different scenario. There are instances where individuals who've committed crimes are given immunity from prosecution. And Advocate Simelane, you'll correct me if I'm wrong here. I'll use another example. Glenn Agliotti was said to have been in a corrupt relationship with the late former police commissioner, Jackie Sleepy. He gets immunity from prosecution because in exchange, the prosecutors wanted to get to the commissioner of police, Jackie Sleepy, who ultimately gets convicted and he gets sent to jail. Again, you have an instance where a criminal is off the hook in exchange for him ratting out, or should we say exposing, let's use professional language, for exposing someone that I guess the prosecutors deemed more important to deal with. In that scenario, would the South African public be appeased that this criminal at least has done good by giving us someone who sits in government, influences public policy, and in exchange, we can let you off the hook by not sending you to jail, but we're going after that one. Is that a fair deal?
The public and the society at large would ultimately like transparency. I've seen articles on the victims speaking about they've been in contact with liquidators of the bank trying to find out what's happening, but there's been no feedback on that. So if the public and the prosecutors can come back with transparency and say this is what's happening, give them updates on the matters, and ultimately do as they are saying. Not only now when it's time, when everything's in the media now, it's let's go after the big guys. Back your words up with your actions. I think that's what the public actually wants.
Yeah. Advocate Simelane,
Yep.
We're wrapping up the conversation now. Talk to us about the thinking here around this individual. I know it's hypothetical.
Yep.
It's a hypothetical conversation we're going into now. Mr. Matodzi, as I mentioned earlier, is probably one of the biggest beneficiaries of this corruption. 300 million rand
Yes.
is the amount that he's said to have taken. For him to have gotten such a light sentence, although Mthunzi Maga from the NPA
Yes.
contends that it's not a light sentence, it is a sentence that they think is appropriate. Yes, he won't disclose the deal because he refuses to tell us whether Mr. Matodzi has gotten or has turned state witness. He refuses to say that part. But what kind of an agreement should we, as members of the public, try to think he has gotten here in exchange for what?
Well, I can understand the caution by Mr. Maga. You wouldn't want to reveal much. But from experience and what is known, I can almost tell you that Mr. Matodzi is a state witness. There is no way he would not be a state witness. Otherwise, that affidavit of his will have trouble being admissible in court. So he's going to have to go to court and repeat what is in that affidavit for that information in that affidavit to be admissible against others. If he's not there in court, the affidavit is hearsay and it's not going to be admissible in court. It's going to be very difficult to get it in there. So the quickest way to make sure that that affidavit is not admissible is if Mr. Matodzi is not around to get to court and repeat what he said on affidavit under oath. But once he does that and they repeat it under oath and then he goes away, it's done for the others because they must now rebut what is in that affidavit, which would be evidence before court and in court and already accepted by the court. So I think the annoyance by the authorities on what they refer to as a leak is in relation to that difficult situation, that they now must make sure that Mr. Matzi comes forward to testify. Because on what he has said at the level at which he was, in all probability, is correct against the people involved. He's the one who can speak closest to what everybody else that he has mentioned has done. And therefore, it's going to be very difficult to disprove what he says. There may be some aspects of it, but it's going to be difficult.
Yeah. His physical appearance in court to back up what he has said in writing. Basically, what I'm asking you is how important is it for the state to protect him, preserve his life, so that he is able to be useful, I guess, in helping to convict others?
Well, that's a primary responsibility of the state now. It's their responsibility to make sure that he's available, and they wouldn't want to undermine their own case by not taking appropriate measures to make sure that he's available. So it's in the state's interest for the rest of the case to make sure that he does make an appearance in court, if not at least virtually. But appropriate arrangements must be made for him to talk before court under oath and be subjected to cross-examination.
Wow. Mr. Singh, any final words? Perhaps I may have skipped something. I'm not aware of the law, and so it is both you and Mr. Simelane's duty to educate us as the public. Is there anything that we are missing here that relates to this case that the public should be aware of?
I think the public just needs to know that there are mechanisms in place to hold state institutions accountable. And if we follow those mechanisms accordingly to the law, and in that way we can get progress on the matter and also reforms, because as you know, the law is always evolving and changing. So because the situation is the way it is now doesn't mean it always has to stay the same. So once the public and the media assist the public by following up and getting more information, because ultimately the public is still of the view that now Mr. Matzi is still going to be benefiting from state resources in prison. He'll still be getting 3 meals a day, you know. So where's the real justice in that? The real justice comes in the restoration process, and that's what the public ultimately needs.
Advocate Simelane, any parting words from you?
Well, I think society in general must be pleased with what the states, the police and the NPA has achieved in getting this far on a matter this big and this complex. It's still going to get more complex because not only because of the people involved, but because of the magnitude of the number of people that must still be dealt with, and how the state deals with each one of them going forward is going to be important. And it will take some time, but at least going forward, the pace is going to be a bit quicker now. I'd imagine that quite a number of them are probably rushing to the nearest police station now to try and get their own plea and sentence agreements, which would be a good idea.
That's very interesting. The political figures here as well, do you think they also rushing to get plea agreements, or is that going to be the bigger fight?
No, really, it doesn't matter who. Most of the accused persons want to hold back and see how far the state can go in what they have. But the more others go forward and conclude their own plea and sentence agreement, the harder it's going to become for some to come forward, because there's going to be a point where the prosecutor is going to say, we no longer need any of you. We've got enough. With what we have, we can get all of you. So it's first through the door. That's the whole point of plea bargain. You know, whoever can run. I know people think politicians can't run because of their size, but you'll be amazed how some can actually run if we need to get through that kind of door.
Advocate Menzi Simelane, I want to thank you very much for your time and explaining these very complicated legal matters at times. And Mr. Singh, I want to thank you very much for your time.
Thank you for having me.
Explaining from the public's point of view what the expectations should be. And I hope all of us at home, at least, we've got some kind of idea of what is happening here, or at least the background to all of these plea agreements.